Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you married a foreigner in the Philippines. You and your spouse move abroad and decide to mutually divorce. Can you have this divorce decree recognized here in the Philippines? And does it matter if you didn't go to court? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 29th of November 2024, and today we talk about the case of Republic versus Ruby Cuevas Nang, decided on February 27, 2024. It's an en banc decision penned by Supreme Court Associate Justice Japar B. Dimaampao. And joining us to talk about this case is Attorney Carol Longalong from the Office of Associate Justice Dimaampao. Hi, Attorney Carol. Thanks for joining us and welcome to the Supreme Court Podcast.
Hi, Attorney Mike. Good day.
Right. So, thanks for joining us. This is a case involving divorce. Tell us what happened here. Who married, where did they marry, and how did they obtain the divorce?
So, Attorney Mike, in this case, Respondent Ruby Nang, a Filipino citizen, and Akihiro Sono, a Japanese national, contracted marriage in Quezon City. And soon after their marriage, the spouses moved to Japan. But after 3 years, they obtained a divorce by mutual agreement under Japanese laws. And they were issued a divorce certificate by the Embassy of Japan in the Philippines. This was recorded in the Civil Registry of Japan, and this was later on also authenticated by the DFA in Manila.
And just to be clear, in Japan, it's legally allowed to obtain a divorce by mutual agreement.
Yes, it is allowed under their laws.
All right. So after they obtained a divorce certificate in Japan, what happened?
So after they obtained a divorce in Japan, Respondent Nang filed a petition for judicial recognition of foreign divorce and declaration of capacity to remarry before the RTC of Quezon City.
Let's just remind our listeners why there's a need to file this petition for judicial recognition of foreign divorce here in the Philippines.
So the answer to that, Attorney Mike, is to date, there's still no absolute divorce here in the Philippines.
Right.
However, jurisdiction is conferred on Philippine courts to extend the effect of a foreign divorce to a Filipino spouse. If the divorce was validly obtained abroad, capacitating the alien spouse to remarry. So, in a petition for judicial recognition of foreign divorce, the divorce decree and the governing personal law of the alien spouse must be proven under our rules of evidence. This is because our courts cannot take judicial notice of foreign laws and judgments.
So, meaning it's not just the fact of divorce outside the country, but also even the law of that country recognizing that divorce that must be proved here in the Philippines.
That is correct.
All right. So, how did the RTC rule in this petition?
So, the RTC held that the divorce obtained by Nang and her foreign spouse in Japan falls within Article 26, Paragraph 2 of the Family Code, and may be judicially recognized here.
When we talk about Article 26, Paragraph 2, what are we referring to? What is that rule?
So, this Article 26, Paragraph 2 deals with mixed marriages between a Filipino spouse and a foreign spouse. And it provides that where a marriage between a Filipino citizen and a foreigner is validly celebrated and thereafter a divorce is validly obtained abroad by the alien spouse, capacitating him or her to remarry, then the Filipino spouse shall likewise have the capacity to remarry under Philippine law.
Here in the Philippines as
Yes.
well, right? So it's only fair because if your husband or wife can remarry abroad, then what does that leave you if you can't remarry here in the Philippines, right?
Yes, that is right.
Okay, that's the logic of Article 26, Paragraph 2. So the Office of the Solicitor General challenged the RTC ruling before the Supreme Court. Before I ask why, what are the arguments of the OSG, remind us why it's the OSG who will challenge usually these types of cases before the Supreme Court.
So, under Article 15, Section 2 of the Constitution, marriage is an inviolable social institution. And the OSG, as the statutory council of the state, defends the sanctity of marriages. So, since the OSG protects the interest of the state, it may oppose applications for judicial recognition of foreign divorce if they don't meet the requirements under the law.
All right. So the OSJ is acting for the state. What were the arguments of the OSG?
So in this case, the OSG opposed the petition on the ground that the divorce was by mutual agreement and not obtained through adversarial proceeding in court. It argues that Article 26, Paragraph 2 of the Family Code applies only to judicial divorce decrees and not those obtained by mutual agreement of the parties. That's their first argument. Their second argument is they claim that Nang failed to prove the Japanese law on divorce because she merely presented a photocopy of the Japanese Civil Code. And this photocopy was not authenticated.
Right. How about Nang? How did she argue about, how about Nang? What are her counter-arguments?
So Nang countered that the joint divorce that she and her Japanese spouse obtained in Japan falls within the exception provided under Article 26, Paragraph 2 of the Family Code. She contends that the divorce by mutual agreement may be recognized in the court's jurisdiction given that the national law of Japan recognizes divorce either by mutual agreement or judicial action. Secondly, she insists that the failure to present an authenticated copy of the Japanese divorce law is not sufficient ground to dismiss her petition.
So to recap, Attorney Carol, two issues before the Supreme Court. One, whether the RTC was correct in judicially recognizing the foreign divorce obtained by mere agreement by the spouses without undergoing a judicial proceeding in a foreign court. And the second one is whether Nang was able to sufficiently prove the divorce decree and the Japanese law on divorce.
That is correct.
So let's discuss the first issue. Can you tell us what are the relevant laws on this matter? I know we don't have a law on divorce. Let's discuss the first issue. What's our legal policy on divorce?
So our Philippine law still does not provide for absolute divorce. So our courts cannot grant it. However, we are guided by certain rules on divorce. So first, consistent with Articles 15 and 17 of the new Civil Code, which embody our nationality principle, the marriage between two Filipinos cannot be dissolved even if they obtain an absolute divorce abroad. So since our national laws follow us wherever we go, as stated under Article 15, Philippine nationals are covered by the policy against absolute divorce.
Right.
Okay, and second, an absolute divorce obtained abroad by a couple who are both aliens may be recognized in the Philippines, provided that it is consistent with their respective national laws. And lastly, in mixed marriages between a Filipino and a foreigner, the Filipino is allowed to contract a subsequent marriage in case the absolute divorce is validly obtained by the alien spouse, capacitating him or her to remarry. And this rule is actually encapsulated in Article 26, Paragraph 2 of the Family Code.
Right. And as you mentioned, this case falls under Article 26, the case of Nang, a marriage between a Filipino and a foreigner. Did the court see this as a valid example of applying Article 26? Is this squarely under that particular provision?
Yes, that is correct. The court ruled that Article 26, Paragraph 2 applies in this case. And in arriving at that conclusion, the court relied foremost on the landmark case of Republic versus Manalo. And in Republic versus Manalo, we remember that the court declared there that Article 26, Paragraph 2 only requires that there be a divorce validly obtained abroad, capacitating the foreigner spouse to remarry without regard as to who initiated it. So, Manalo instructs that two elements must be present in order for Article 26, Paragraph 2 to apply. And these are, first, there must be a valid marriage that has been celebrated between the Filipino citizen and the foreigner spouse. And second, a valid divorce is obtained, capacitating the parties to remarry, regardless of the spouse who initiated the divorce proceedings. And, Attorney Mike, this doctrine was reiterated in a litany of subsequent cases. And in all those cases, the court has remained consistent in its stand that a foreign divorce decree may be recognized in the Philippines regardless of the spouse who initiated it, provided that the divorce is valid according to the national law of the foreign spouse.
Right, let's break that down because it's very clear now that a foreign divorce can be valid even if it was the Filipino spouse who obtained it. But how about the nature of the divorce? Does it matter if it was issued by a court or by an administrative tribunal or by mere mutual agreement of the parties? Because there are at least two justices who descended on this point. Justices Ramon Paul Hernando and Maria Filomena Singh think that Article 26, Paragraph 2 of the Family Code should only apply to judicial divorce decrees validly obtained abroad, not by mere agreement.
So this was actually the first issue resolved by the court in this case.
Mhm.
The issue as to whether or not a divorce by mutual agreement may be recognized in our jurisdiction. And in answering in the affirmative, the court was guided by three basic principles of statutory construction.
Mhm.
Okay, the first principle is the plain meaning rule.
Okay.
And this rule provides that where the words of a statute are clear, plain, and free from any ambiguity, they must be given their literal meaning and
Mhm.
applied without any attempted interpretation.
Mhm.
And in this case, a plain reading of Article 26, Paragraph 2 reveals that it only requires that the divorce be validly obtained abroad, nothing
Mhm.
more.
Mhm.
So since Article 26, Paragraph 2 of the Family Code only requires that the divorce be validly obtained abroad, the court cannot impose additional distinctions and qualifications.
Right. Mhm.
And this is where the second rule of statutory construction comes in. Where the law does not distinguish, the courts also should not distinguish.
Mhm.
So, to require that the divorce be obtained through a foreign court is to insert a condition not provided in the law.
Mhm.
And this is exactly where the problem in the OSG's argument lies.
Mhm.
The OSG's view was restrictive in the sense that only divorce by judicial decrees may be recognized,
Mhm.
no other form. And had the court agreed with the OSG, it would have been tantamount to judicial legislation, which
Mm.
is an unwarranted overstepping of the court's judicial functions.
Judicial legislation because it's not written in the provision of the law for the court to step in and say that there's this distinction.
Yes, that is correct. Because the law does not distinguish between divorces obtained through judicial proceedings and administrative proceedings, or between those where one spouse files for divorce and the other contests it,
Mhm.
and those where the divorce is a product of mutual agreement.
Mm. Mhm.
And lastly, to test the OSG's argument and to provide a glimpse of the underlying spirit or intent of Article 26, Paragraph 2, the court relied on another rule
Mhm.
on statutory construction. So the court ruled that assuming that Article 26, Paragraph 2 of the Family Code is not clear and
Mhm.
is subject to several interpretations, still, the OSG's argument was bound to be rejected
Mhm.
because
So,
we go back to the well-settled rule that a statute must be read according to its spirit or intent.
mm.
So courts should not interpret and should not accept an interpretation that would defeat the intent of the law.
Mm.
And here, the legislative intent behind Article 26, Paragraph 2 of the Family Code is precisely to correct the unjust or anomalous situation where the foreign spouse is free to remarry
Mhm.
while the Filipino spouse is not.
Right.
Because as it is, separations are never easy, and the Filipino spouse shouldn't have to suffer anymore as compared to his or her foreign counterpart.
Mhm.
So like the foreign spouse, the Filipino spouse should be free to marry again.
Mhm.
So, borrowing the words of Saj Leonen, the statutory provision focuses on the effect of the foreign divorce on the Filipino spouse.
Mhm.
Because it would be unjust for a Filipino spouse to be prohibited by their own national laws from something that a foreign law may allow.
Mhm.
Clearly, our law should not be intended to put Filipinos at a disadvantage.
Right. So it doesn't matter whether it's from a court or by mutual agreement because the effect is the same to allow the foreigner to remarry, and it would be unfair if the Filipino cannot remarry. So that's clear that it can be any mode. It's not just obtained by a foreign court. But in this particular case, how did the court rule? Was Nang able to prove that the divorce by mutual agreement was validly obtained and recognized?
Yes, following our discussion earlier, the divorce by mutual agreement between Nang and her spouse was validly obtained.
Mhm. But Attorney Carol, doesn't recognizing a divorce by mutual agreement, can that be considered collusion under our laws?
No, Attorney Mike, it does not. Because the fact that the parties opted for divorce by mutual agreement does not necessarily mean that they resort to machinations like collusion.
Mhm.
This is because there's a huge difference between agreement and collusion.
Mhm.
So, an agreement is defined as a mutual understanding between two or more persons about their relative rights and duties regarding past or future performances.
Mhm.
So, in short, it is a manifestation of mutual assent by
Mhm.
two or more persons. On the other hand, collusion is defined as a secret agreement which is for an illegal or deceitful purpose,
Mhm.
specifically as between married couples. It is an agreement between a husband and wife for one of them to commit or to appear to commit a matrimonial offense or
Mhm.
to suppress evidence of a valid defense for the purpose of enabling the other to obtain a divorce. And in this case, a divorce by mutual agreement can hardly be considered a form of collusion because, first, this agreement appears to be sanctioned by the Japanese Civil Code
Mhm.
as a mode of terminating marriage.
Mhm.
Second, the agreement is not for the purpose of circumventing any law.
Mhm.
And third, there is no misrepresentation or fabrication or suppression of evidence or a ground for divorce involved.
Mhm.
And as the Honorable Chief Justice correctly pointed out in his concurring opinion, the legal safeguard against collusion is present in cases involving annulment or declaration of absolute nullity of marriage, where the marriage has not yet been dissolved.
Mm.
And such safeguard against collusion does not apply in cases seeking judicial recognition of foreign divorce, as in the present case, because here, the marriage has already been dissolved and the
Mhm.
foreign spouse is already recapacitated to remarry. So, what is left for the Filipino spouse to prove is that the foreign divorce decree was validly obtained abroad.
So in this case, you don't need to go into how that foreign decree was obtained, only that it is valid,
Yes.
right? And so, I mean, also, how can there be collusion if it's recognized by Japanese law that you can mutually agree to divorce?
Yes.
What's the collusion for? What's the need for the collusion? So, but in this case, how do you prove the fact of divorce in a Philippine court?
So, in order to prove the fact of divorce and the foreign divorce law, the rules require the petitioner to comply with sections 24 and 25
Mhm.
of Rule 132 of our revised rules of evidence. So, to summarize, the rules require proof either by official publications
Mhm.
or by copies attested by the officer having
Mhm.
legal custody of the documents.
Mhm.
And should the copies of official records be proven to be stored outside of the Philippines,
Mhm.
they must be accompanied by a certificate issued by the proper diplomatic or consular officer in the Philippine Foreign Service stationed in the foreign country in which the record is kept, and it must be authenticated by the seal of their office.
Mm.
So, the need to prove the foreign law can be traced from the basic rule that our courts do not take judicial notice of foreign laws and judgments.
Mhm.
So, our law on evidence requires that both the divorce decree and the national law of the alien spouse must always be proven.
So in this case, was Nang able to prove the fact of divorce in Japan?
Yes, Attorney Mike. In this case, Nang was able to sufficiently prove the fact of divorce when she submitted into evidence the following documents. She
Mhm.
submitted an authenticated divorce certificate issued by the Embassy of Japan in the Philippines.
Mhm.
She likewise submitted a certificate of acceptance of notification of divorce.
Mhm.
She also proffered in evidence a certification by the Civil Registry of Manila, acknowledging that a divorce certificate was filed and recorded in its office.
Mhm.
And she also presented an original copy of the Family Registry of Japan, issued by the Mayor of Tokyo, with its English translation,
Mhm.
which shows that the fact of divorce was actually recorded in the Civil Registry of Japan. So, The court ruled that these pieces of evidence satisfactorily prove the fact of divorce.
But as you mentioned earlier, it's not just the fact of divorce that needs to be proved, also the law in Japan on divorce.
Yes.
So, how about the relevant Japanese law? Was she able to prove this?
No, she wasn't able to prove this because while the court ruled that she was able to sufficiently prove the fact of divorce, she presented a mere photocopy of the Japanese civil law on divorce, which wasn't authenticated.
Right.
So the court ruled that in this case, she was unable to prove the relevant Japanese law.
A point here was made about the existence of a circular from the Office of the Court Administrator, which supposedly lays down the rules on, or the foreign laws on marriage and divorce. Is it not enough judicial notice of the foreign laws on divorce? Or is there still a need to prove that despite this OCA circular?
Okay, so just to give you a background, to address the increasing number of petitions filed before Philippine courts for recognition of foreign divorce, and the sudden influx of requests for certified true copies of foreign divorce laws, the OCA, the Office of the Court Administrator, requested the DFA to furnish it with a compilation of several foreign laws on marriage and divorce, which is for the reference and use of the judiciary in resolving petitions for recognition of foreign divorce decrees. So accordingly, on June 23, 2022, the OCA issued Circular Number 157-2022 entitled Compilation of the Laws of Foreign Countries on Marriage and Divorce. And it furnished all regional trial courts with copies of the divorce laws and their English translations, which were submitted to the DFA by its foreign counterparts. Notably, this OCA circular advised the family courts to take judicial notice of this compilation of foreign laws in the resolution of cases requiring the presentation of such laws. However, a few weeks after, or on July 7, 2022, OCA Circular Number 157-2022 was superseded by another OCA circular, which was OCA Circular Number 157-2022-A. So the provision in the first OCA circular advising family courts to take judicial notice of the compilation of foreign divorce laws was deleted and effectively abandoned in this subsequent OCA circular. As it now stands, the existing OCA Circular Number 157-2022-A emphasizes that this compilation of foreign laws on marriage and divorce may be used as reference by the courts in resolving petitions for recognition of foreign divorce decrees, subject to prevailing jurisprudence and applicable court issuances related thereto. So this added clause leads to no other conclusion than that although the OCA's compilation is helpful in enabling courts to have a preliminary copy of these laws, we are still not allowed to take judicial notice of these foreign divorce laws because it still does not dispense with the requirement of the parties to comply with Sections 24 and 25 of Rule 132. So in this case, the court remanded the case to the trial court for further reception of evidence in order to give Nang the opportunity to present proof on the foreign law on divorce.
Right. So, very interesting. We now know that even if it's a Filipino obtaining a divorce decree abroad, if married to a foreigner, it can still be recognized in the Philippines. At the same time, it doesn't matter if it's whether through the courts or mutual agreement, and the fact that you have to prove the foreign law here in the Philippines. So, just to close our discussion, Attorney Carol, what's our main takeaway from this case?
So, the main takeaways from this case are, first, regardless of the modality by which the foreign divorce was obtained, whether it is by adversarial proceeding or by mutual agreement, as long as the divorce was validly obtained according to the national law of the foreign spouse, its effects must extend to the Filipino spouse, and the divorce must be recognized here in the Philippines. That's the first takeaway. The second is, this is actually the first time that the court clarified the applicability or the effectivity of OCA Circular number 157/2022-A. So this clarification was inevitable because it is possible that litigants may have viewed this circular and relied on it for whatever legal purposes. Or Filipinos who are facing the same situation as Nang, or lawyers preparing pleadings for Filipino spouses who wish to have their foreign decrees recognized in the Philippines may have likewise referred to this circular. So the ruling in this Republic versus Nang serves as some sort of notice or guidance to the public as to the applicability or effectivity of the circular. And it clarifies that our courts still cannot take judicial notice of foreign divorce laws, even with the presence of this compilation by the OCA. So the takeaway is these foreign divorce laws must still be proven like any other fact.
Right, and that's a very, very important reminder, Attorney Carol. So thank you for sharing your thoughts with us today.
Thank you very much, Attorney Mike.
All right, and if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Republic versus Ruby Cuevas Nang, GR number 249238, February 27, 2024. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week, the Supreme Court denied the motions for partial reconsideration filed by the Bangsamoro Autonomous Region in Muslim Mindanao Government, the Office of the Solicitor General, and others. These motions sought to reverse the court's decision on September 9, 2024, which excluded the province of Cebu from the BARM. The decision is final and immediately executory, and the court will no longer entertain further pleadings. The Supreme Court also resolved to amend Rule 13 of the 2019 amendments to the 1997 Rules of Civil Procedure to provide for the mandatory electronic filing in service for civil cases in the first and second level courts. The court issued Rule 13-A, or the interim rule on the electronic filing in service of pleadings, judgments, and other papers in civil cases. This interim rule shall take effect on December 1, 2024, following its publication in the Official Gazette or in 2 newspapers of national circulation. Beginning December 1, 2024, all filing in service of pleadings, judgments, and other papers in civil cases in the trial courts must be done electronically through mail except for initiatory pleadings. The Office of the 2024 Bar Chairperson issued a notice announcing that the results of the 2024 bar examinations will be released on December 13, 2024. The results will be displayed on LED walls inside the SC courtyard and uploaded to the Supreme Court's official website and social media pages. The Supreme Court reiterated that child abuse cases can still be tried even when child victims are unable to testify in court, in accordance with the doctrine of unavailable child under Section 28 of the Rule on Examination of a Child Witness. It allows the admission of hearsay testimony of a child describing child abuse when 1. The child is unavailable due to death, physical disability, lack of memory or mental illness, possible exposure to psychological injury, or lack of reasonable means, and 2. Their hearsay testimony is supported by other evidence. This aims to prevent miscarriages of justice by allowing child abuse cases to proceed even if the child victim is unavailable. The court recognized that vulnerable children may be pressured to avoid attending hearings to prevent them from testifying. Some child victims may also be too traumatized to give their testimony. From November 27 to 30, the Supreme Court held the National Summit on Sustainability and Environmental Law. Guided by the theme, Enabling Environmental and Climate Justice, Bridging Science and Laws for Responsive Rules and Sustainable Development, a panel of experts discussed a wide range of relevant topics including climate change, energy issues, and environmental law practice. On November 28, the Office of the 2025 Sharia Bar Chairperson Associate Justice Antonio T. Ko Jr. issued Sharia Special Bar Bulletin Number 1 on the schedule, venues, coverage, and other matters relating to the 2025 Sharia Special Bar examinations. The office also released the 2025 Sharia Special Bar Examinations syllabi. Visit the 2025 Sharia Bar microsite on the Supreme Court website for more information. Finally, the court has established guidelines for when a confiscated firearm must be presented as evidence in court. The court acknowledged that in previous cases, it had stated that the actual firearm does not need to be presented as evidence. To prevent confusion that could lead to the imposition of incorrect penalties, or even worse, the conviction of an innocent person, the court established the following guidelines on when the confiscated firearm must be presented in court. 1. Where an accused is charged with a violation of the Comprehensive Firearms and Ammunition Regulation Act, the exact same firearm confiscated must be presented in court. 2. When the use of a firearm is a qualifying circumstance, or when it changes the nature of the crime, and the penalty imposable depends on the classification of the firearm, the exact same firearm confiscated must be presented in court. 3. When the use of a firearm is an aggravating circumstance, or when it increases the penalty to the maximum period imposable, or is inherent in, or absorbed by the nature of the crime charged, the exact same firearm confiscated is preferred, but the presentation of secondary evidence may also be considered. And 4. In all situations where a firearm is confiscated from an accused, the confiscated firearm must be marked, photographed, and duly authenticated, and its integrity preserved.
And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Victor Laranio,
Brian Austriac,
and Don Ryan Balza as sound editors, and Ty Flores and Jerome Batumalaki as web editors.